On the 29th of March, Prime Minister Scott Morrison made it clear that he'd like to see landlords and tenants sit down and work out solutions to survive the COVID-19 period. The starting point is that nobody should assume that their lease, or any contract for that matter, ends automatically because of COVID-19. In fact, for the reasons discussed below, most landlords and tenants will remain in a binding lease. There may, as with most things in law, be exceptions. Every lease and every arrangement is different. That's why it's so important to get specific advice in relation to your particular lease and circumstances. The best approach is to seek to agree on a mutually acceptable solution to both the landlord and tenant. COVID-19 is neither party's fault, and each party will have their own financial pressures. So I really encourage people to approach any discussion or negotiation with a sense of empathy for the situation that the other party is in. Now is really the time for a commercial approach, cool heads, and a level of practicality to finding solutions. I've considered some frequently asked questions from a tenant's perspective. I hope this serves as a useful starting point, but I can't stress enough the importance of obtaining specific advice. For example, your particular lease may have a provision which means the answer to one of the questions is entirely different because of a specific clause in your lease. As part of the Prime Minister's announcement for commercial landlords and tenants, there's a 6-month moratorium on evictions. We haven't seen the finer detail of this as yet, but there is a set of commercial tenancy principles. In the links below this video, I've included a link to the media statement with those commercial tenancy principles. Question 1. If required by the government to close my business, will I have to comply? Yes, you will have to comply. State and federal governments have very broad powers to deal with events like this, COVID-19. Question 2. Can I rely on the usual rent abatement clause in my lease? Rent abatement or rent reduction sometimes happens when your premises is damaged or destroyed. Typically, this physical damage is required before there's any rent reduction. So because COVID-19 doesn't actually cause any physical damage, it's unlikely these rent abatement clauses will apply. When negotiating with a landlord, essentially any workable, mutually agreeable solution is open to you. Bear in mind that things are unfolding very quickly and people are waiting for announcements. It may be possible that further assistance might be granted to landlords or tenants, so landlords may not wish to lock themselves into any particular arrangement right now as we await further detail. In terms of possible rent relief solutions, here's a few options. Option A, discounted rent. So this is a rent reduction of a certain percentage for a certain period of time. So for example, you might have a 30% rent reduction for a 6-month period, or you might have a 50% rent reduction for a 3-month period, whatever you agree on with the landlord. Option B, no rent, but with a lease extension. So for example, there might be effectively an agreed period of no rent or rent-free for 3 months, but the lease term at the end has 3 more months added on, so a lease extension. Option C, deferred rent amortized out over the remaining term of the lease. So for example, we might take a time period of 6 months and defer that rent to be paid in an amortized way over the rest of the lease. So essentially we would add up the total amount of rent that has been deferred and divide that up equally over the remaining monthly payments. That way it makes it affordable for the tenant, and it ultimately means that the landlord is not really worse off. And so that way there's a solution for the tenant in terms of providing some immediate cash flow relief, but ultimately the landlord ends up receiving the same amount of rent at the end of the day. You might also consider some hybrid of the above or some other creative solution. Parties may also need to talk to their accountant about any tax or other consequences of these arrangements. Question 4. Can the landlord close my shop before it's legally required? Strictly speaking, no. However, some landlords may move to do this at some stage. This may be able to be achieved with discussion, negotiation, and mutual agreement with affected tenants. Alternatively, a landlord may choose to take action based on specific circumstances. For example, a particular outbreak in their shopping centre. In that case, a tenant may have rights to damages or otherwise. This would be a pretty tricky or complex situation, and so if you're a tenant in this situation where your landlord is closing voluntarily rather than being required under law, it's best to seek specific advice. Question 5. Can you be required to leave if your lease expires during the 6-month moratorium on evictions? We don't know the answer to this until we see the further detail in the state-based legislation that will be passed. Normally, if you're a tenant and you haven't exercised any further option and your lease comes to an end, a commercial lease, then you would need to move out. Your lease will have expired. However, given the government's objectives to ensure business continuity, there may be something in the provisions that are to be brought in that deals with this situation. So essentially a wait and see process, but typically a tenant would be able to leave at the end of their lease. And of course, it may be that the tenant actually wants the lease to end, because of course then so does their obligation to pay rent. So I don't think it would be the case that the government would pass any laws requiring a tenant to stay longer than what they would be required to stay under their existing lease. Question 6. Will your business interruption insurance cover this COVID situation? Your insurance could cover all or some of the losses associated with COVID-19. This may be because you have specific cover for a situation like COVID-19, being a viral pandemic or infectious disease or some sort of specific cover like that, or alternatively, just because you have general business interruption insurance. You would need to check the policy terms, firstly for what you're covered for, and also for any exclusions that mean that you are no longer covered. For example, there may be exclusions for epidemics, pandemics, infectious diseases, disease outbreaks, etc. In the case of business interruption insurance, loss is often tied to some form of physical damage, either to the premises or to your business property, your plant and equipment, etc. So the lack of physical damage associated with COVID-19 may mean that there is no cover under those policies. So the terms of the policy will need to be reviewed carefully by your insurer or broker or a solicitor experienced in insurance law. Thanks very much, guys, for tuning in and listening to this video. Hopefully there's been some helpful information. Unfortunately, it's a day-by-day thing. I'm reading as much as I can and absorbing a lot of information. Bear in mind that there's going to be further information come out. Unfortunately, it's an evolving thing. And so if we can help in any way, feel free to give me a call or reach out. Stay safe out there, negotiate with empathy, and be kind to each other. Cheers. Fox out.